हेलो नमस्कार एंड गुड इवनिंग एवरीवन, दिस इज मी आकृति और मैं आप सबका स्वागत करती हूँ टू आवर चैनल अड्डा 247 जुडिशरी पर। तो हम कर रहे हैं हमारी जो क्लास होती है 5 से 6 में, वहाँ पर हम करते हैं प्रीवियस ईयर क्वेश्चन पेपर्स सॉल्व हरियाणा जुडिशरी के। आज हम लेके आए हैं एक्सपेक्टेड क्वेश्चंस जो कि हम डिफरेंट सब्जेक्ट से डील करेंगे। पहले हम सीआरपीसी देखेंगे, आईपीसी भी देखेंगे, एविडेंस और सीपीसी। तो ये क्वेश्चंस हम आज डील करने वाले हैं। सो लेट्स गेट स्टार्टेड। Join the session, share it with your friends, like it and also comment जहाँ पर आपको लगता है कि ये आंसर सही है, आप अपना एक्टिव पार्टिसिपेशन भी दिखाइए। सो गुड इवनिंग टू एवरीवन। So shall we start? Under the provisions of Code of Criminal Procedure 1973, confessions option A can only be made to the authorized persons. Option B, only the magistrate enjoys the power of recording the confessions. Option C, made to the police officer are valid. Option D, made by the accused while in the police custody to a police officer is valid. What is the correct answer? What is the correct option of this particular question? बताइए क्या सही आंसर होगा इस क्वेश्चन का। So the correct answer of this particular question is option B, that only the magistrate enjoys the power of recording the confession, because we know कि पुलिस ऑफिसर को जो कन्फेशन दी जाती हैं वो वैलिड नहीं है। कहाँ लिखा है? सेक्शन 25 ऑफ द इंडियन एविडेंस एक्ट। एंड इफ इट इज मेड टू द एक्यूज्ड व्हाइल इन द पुलिस कस्टडी, दैट इज ऑल्सो नॉट वैलिड। कहाँ पे दिया है? सेक्शन 26 में बताया है। तो सीआरपीसी में जो भी कन्फेशंस दी जाती हैं, only the magistrate enjoys the power of recording the confessions. Which section? Section 164 of the CRPC. ठीक है, clear? Okay, moving ahead. Second question. Under section 164 of the CRPC, option A, only the statement of a person produced by the police or investigation agencies can be recorded. Statement of the person approaching the magistrate independently can be recorded. The statement made need not be voluntarily. The police officer is authorized to record the statement. Which option is the correct option? Which option is the correct option? Under section 164 of the CRPC, only the statement of a person produced by the police or investigation agencies can be recorded. Statement of the person approaching the magistrate independently can be recorded. Statement made need not be voluntary, or the police officer is authorized to record the statement. What is the correct option of this question? Do let me know. बताइए। बताइए क्या करेक्ट आंसर है? So the option A is the correct answer. Option A is the correct answer. Do refer section 164 for this. तो जो इंसान पुलिस जो है प्रोड्यूस करती है, उन्हीं की स्टेटमेंट जो है वो यहाँ पर अंडर सेक्शन 164 रिकॉर्ड करी जाती है। कोई भी जिसका मन आया वो आके मैजिस्ट्रेट को स्टेटमेंट देने लगे, ऐसा पॉसिबल नहीं है। ठीक है, क्वेश्चन नंबर 3, Which of the following statement doesn't hold true for the confessions made to the magistrate under the provisions of CRPC? First, it is the duty of the magistrate to exclude the presence of the police officer from the place where the confession is recorded. आपको बताना है कि कौन सी स्टेटमेंट सही नहीं है, which is not true for the confessions. Is it obligatory for the magistrate to warn the accused before recording his confession that he is not bound to make it, and that if he does so, it may be used as evidence against him? The accused should be sent back to police custody as soon as the confession is recorded. Option D, it is necessary for the confession to be signed by the accused. What is the correct answer? What is the correct answer? आपको बताना है कन्फेशन से रिलेटेड कौन सी स्टेटमेंट इसमें से ट्रू नहीं है, कौन सी स्टेटमेंट इसमें से गलत है. यू हैव टू टेल दैट थिंग. बताइए. So the correct answer for this question is option C. ऑप्शन सी जो है वो कन्फेशंस के रिगार्ड में एक सही स्टेटमेंट नहीं है, ये एक गलत स्टेटमेंट है कि अक्यूज शुड बी सेंट बैक टू पुलिस कस्टडी एज सून एज द कन्फेशन इज रिकॉर्डेड. दिस इज अ रॉन्ग स्टेटमेंट रिलेटेड टू कन्फेशन. ओके. Which of the following is true of section 31 CRPC? तो यहाँ पर सेक्शन 31 की बात हो रही है. ऑप्शन ए, इट रिलेट्स टू द क्वांटम ऑफ द पनिशमेंट दैट द कोर्ट हैज जुरिसडिक्शन टू पास वेयर द अक्यूज्ड इज कन्विक्टेड ऑफ 2 or more offences at one trial. ऑप्शन बी, इट इज द रूल ऑफ द प्रोसीजरल लॉ. ऑप्शन सी, ईदर ए और बी. ऑप्शन डी, बोथ ए एंड बी. So what is the correct answer? What is the correct answer? The correct answer to this is both A and B. Both A and B. Because this statement is also true with regards to section 31, and this is also true with regards to 31, because all the provisions of the CRPC deals with the procedural law. As simple as that. Now, which of the following statements is not true regarding the charge sheet made under the provisions of CRPC? Now they are talking about the charge sheet. चार्ज शीट को आप पुलिस रिपोर्ट भी कह सकते हैं, जो 173 क्लॉज 2 में दी जाती है बाय द पुलिस ऑफिसर आफ्टर द कंप्लीशन ऑफ द इन्वेस्टिगेशन. ऑप्शन, इन केस ऑफ ऑफेंस ऑफ ए रेप ऑफ ए चाइल्ड द चार्ज शीट मस्ट बी सबमिटेड विद इन 3 months. After submission of the charge sheet, there cannot be any further investigation into the case by police. The right to be released on bail is lost once the charge sheet is filed. Charge sheet against absconding accused can be filed even if the accused is not arrested. Which option and which statement among all these statements is not true regarding the charge sheet? Question number 5. So the correct answer is this. Because section 173 clause 8 किस बारे में बात करता है? आपका फर्दर इन्वेस्टिगेशन के बारे में. ठीक है, फर्दर इन्वेस्टिगेशन के बारे में बात करता है. तो 173 क्लॉज 2 में इवन इफ यू हैव फाइल्ड द पुलिस रिपोर्ट और चार्ज शीट, तब भी उसके बाद भी फर्दर इन्वेस्टिगेशन का जो डायरेक्शन है वो दिया जा सकता है. कौन सी सेक्शन बोलती है वो? 173 क्लॉज 8 ऑफ द CRPC. In which of the following cases will the provisions of section 197 of the Code of Criminal Procedure apply? जो 197 है वो किससे डील करता है? Prosecution of the judges, prosecution of judges and public servants. Option A, a magistrate writing a letter to the district judge that an advocate is rowdy, a big gambler, a mischievous element. Block development officer lodging a FIR against the sarpanch and secretary of a gram panchayat under section 409 and 34. A complaint against the personnel at the BSF alleging that illegal gratification of rupees 10,000 was demanded from the complainant, and on his refusal to pay, his shop was ransacked and goods taken away. A judge charged with using defamatory language to a witness during a trial of his suit. So what is the correct option of question number 6, and which statement is correct related to section 197 of the CRPC? Question number 6. So question number 6 का जो right answer है वो ये है, because here the judge has used the defamatory language. यहाँ पर जज की जो क्या है मिस्टेक है, गलती है, उसने एक ऑफेंस किया है. बाकी सब केसेस में क्या कोई ऑफेंस हो रहा है? The answer is no. The answer is no. Which of the following requirements need not be followed under section 200 of the CRPC? The complainant must be examined. Examination of the complainant must be under oath. The accused must be given an opportunity to be heard. The examination of the complainant must be reduced to writing. So which statement is not right in connection to section 200 of the CRPC? Question number 7th. जो आपका सेक्शन 200 है दैट डील्स विद द एग्जामिनेशन, ठीक है, एग्जामिनेशन ऑफ द कंप्लेनेंट. तो यहाँ पर अगर सेक्शन 200 डील ही कंप्लेनेंट से कर रहा है तो वहाँ पे आपको कहीं पर भी अगर चॉइस में एक्यूज्ड दिख जाए तो एलिमिनेट दैट थिंग, बिकॉज जो सेक्शन 200 है वो एक्यूज्ड के बारे में तो बात कर ही नहीं रहा है. तो आपका ऑप्शन जो करेक्ट हो जाएगा दैट विल बी ऑप्शन सी, कि ये जो स्टेटमेंट है विद रिगार्ड टू सेक्शन 200 इज रॉन्ग स्टेटमेंट. ठीक है, मूविंग अहेड टू क्वेश्चंस ऑफ द इंडियन पीनल कोड. मूविंग अहेड टू सॉल्विंग द क्वेश्चंस रिलेटेड टू इंडियन पीनल कोड. Five persons went to the house of Z armed with clubs to beat Z. Among these, one A was carrying a pistol, concealing it underneath his clothes. During beating, A fired a shot, resulting in Z's death. Only A will be liable for causing the death. All of the above will be liable for beating Z. All of the above, being the members of unlawful assembly, will be liable for causing death, or none of the above. Which option is correct of question number 1? Which option is correct of question number 1? 5 persons went to the house of the Z armed with clubs to beat Z. Among these, one A was carrying a pistol, concealing it underneath his clothes. During beating, A fired a shot, resulting in Z's death. Only A will be liable. All of the above will be liable. All of the above, being the members of unlawful assembly, will be liable, or none of the above. Question number 1. Which option will be correct? The correct answer will be only A will be held liable for causing the death. Reason being कि बाकी पांचों को तो पता ही नहीं था कि ए जो है पिस्टल भी लेके जा रहा है. उनका जो मोटिव था, जो कॉमन ऑब्जेक्ट था, दैट इज द बीटिंग. कॉमन ऑब्जेक्ट क्या था? बीटिंग था, ना कि उसको मार देना. तो यहाँ पर अगर ए ने ऐसा कुछ किया है और बाकियों को इसके बारे में कुछ नहीं पता है तो वो कॉमन ऑब्जेक्ट की कैटेगरी में जो है फॉल नहीं करेंगे. इसीलिए जो इसका करेक्ट आंसर होगा दैट विल बी योर आंसर, दैट विल बी योर ऑप्शन ए. In which case stretchy justice held that a man must not make or try to make others feel enmity of any kind towards the government? Is it option A, Queen Empress versus Bal Gangadhar Tilak? Option B, Queen Empress versus Jogendra Chandra Bose? Option C, Emperor versus Sadashiv Narayan? Option D, Emperor versus Beni Bhushan Roy? Which is the correct answer? Read the statement what the justice held. They held that a man must not make or try to make others feel enmity of any kind towards the government. So the correct answer to this is option A. इस केस में ये हेल्ड किया था जस्टिस ने consent known to be given under fear or misconception is stated in which section? Section 90, section 91, section 92 और section 93 of the IPC. कहाँ पर ये बोला गया है कि when you give the consent under fear or misconception, वो कंसेंट जो है फ्री कंसेंट की डेफिनेशन में फॉल नहीं करता है, और ये कौन सी सेक्शन में बताया गया है? कौन सी सेक्शन में बताया गया है? विच सेक्शन? आंसर कीजिए, कौन सी सेक्शन में बताया गया है ये आईपीसी की? So the correct answer is section 90. Section 90 is the correct answer. Moving ahead to question number 4. Which one of the following cases is not related with section 84? Ashruddin Ahmed versus King, R versus Dudley and Stephens, Daya Bhai Chhagan Bhai Thakur versus State of Gujarat, State of MP versus Ahmedullah. Which case is not related to section 84 of the IPC? बताइए, पहले ये बताइए सेक्शन 84 क्या है? बताइए. जो आपका सेक्शन 84 है, that deals with unsoundness of mind. अनसाउंडनेस ऑफ माइंड से डील करता है सेक्शन 84. तो ऐसा कौन सा केस है जो कि इस कैटेगरी में फॉल नहीं कर रहा है? बताइए. क्वेश्चन नंबर 4 का करेक्ट आंसर. So this case is not related to section 84 because ये वाला केस if you remember ये नेसेसिटी की सेक्शन में फॉल करता है. ठीक है, ये कौन सी नेसेसिटी की सेक्शन में जो है फॉल कर रहा है? आर वर्सेस डुडले एंड स्टीफेंस. करेक्ट, अंडरस्टूड. बताइए, सबको समझ में आ गया? दिस इज द सेक्शन 81. जो आर वर्सेस डुडले एंड स्टीफेंस का केस है वो नेसेसिटी की सेक्शन में फॉल करता है. तो यू कैन एलिमिनेट दिस केस कि ये वाला तो है नहीं. इट मीन्स it is not related to section 84 because your section 84 talks about the unsoundness of mind. Okay. Question number 5. Which of the following offence is punishable only and only in the attempt stage? Section 307, section 309, section 511 or all of the above? Question number 5. That it is punishable only in the attempt stage. गुड इवनिंग टू एवरीवन। अब क्वेश्चन सॉल्व कीजिए। दिस इज पनिशेबल ओनली इन द अटेम्प्ट स्टेज। बताइए, जो सेक्शन आपका 309 है वो किससे डील कर रहा है? सुसाइड से। अगर बंदा मर गया तो उसको आप क्या पनिशमेंट दोगे? उसने अटेम्प्ट किया है तभी तो पनिशमेंट होगी। जब वो मर ही गया तो उसको तो कोई पनिशमेंट मिल ही नहीं सकती है। सो दैट इज वाई योर सेक्शन 309 ऑफ द आईपीसी इज पनिशेबल ओनली इन द अटेम्प्ट स्टेज। Whoever commits the offence of undue influence or personation at an election shall be punished under section 171E, 171F, 171C, 171B. A direct question, section based question. बताइए क्या होगा इसका करेक्ट आंसर? What is the correct option of question number 6? So the correct option is section 171F. Mark the incorrect statement. Option A, in an unlawful assembly or riot there must be 5 or more members, and effray can be committed by 2 or more. An unlawful assembly or riot can take place in a public or a private place, and effray must take place in a private place only. Mark the incorrect statement. सो प्रणव जैन वॉन्ट्स टू प्ले कौन बनेगा करोड़पति। मैम डी लॉक कर दीजिए। ठीक है, कर देते हैं लॉक। और आप जीत गए हैं कुछ भी नहीं, यहाँ पे कुछ नहीं मिलेगा। सो यस, द करेक्ट आंसर इज ऑप्शन डी। अब आपके जो क्वेश्चंस आएंगे वो एविडेंस एक्ट से रिलेटेड होंगे, ठीक है। Generally, dying declarations are admissible as evidence under Section 20, Section 25, Section 32, Section 35। ये तो आंसर सबको पता होना चाहिए, इसलिए सब बताएं इसका क्या करेक्ट आंसर होगा। इट्स वेरी इजी क्वेश्चन। Dying declarations are admissible as evidence under which of the following sections of Indian Evidence Act? The correct answer is Section 32. Section 32 of the Indian Evidence Act deals with dying declaration. Question number 2. Which of the following statements hold true for dying declaration? Dying declaration cannot be used as a sole basis of conviction. Dying declaration, unless corroborated, cannot be used as sole basis of conviction. Dying declaration which is brief must be discarded. When eyewitness affirms that the deceased was not in a fit state to make the declaration, medical opinion cannot prevail. So which statements hold true for the dying declaration? Question number 2. Which statement hold true for dying declaration? पहली स्टेटमेंट देखिए, डाइंग डिक्लेरेशन को एज अ सोल बेसिस ऑफ कन्विक्शन जो है यूज किया जा सकता है जब मैजिस्ट्रेट को, अगर स्टेटमेंट मैजिस्ट्रेट ने रिकॉर्ड की है, देन डाइंग डिक्लेरेशन इज अ सब्सटैंटिव पीस ऑफ एविडेंस एंड येस इट कैन बी अ बेसिस फॉर कन्विक्शन। तो पहला ऑप्शन तो आप एलिमिनेट कर दो। तो बताइए अब क्या कौन सी स्टेटमेंट जो है इट इज करेक्ट with regards to dying declaration. Question number 2. So the correct answer is option D. Option D is the correct answer. Moving ahead, in which of the following cases the evidence given by the witnesses will not be relevant under Section 33 of Indian Evidence Act? When the witness is staying abroad, when the witness is dead, when the witness cannot be found, when the witness is in coma. Evidence given by the witness will not be relevant under Section 33. Question number 3. Which of the following cases the evidence given by the witnesses will not be relevant under Section 33 of Indian Evidence Act? Which option is correct? तो आपका जो ऑप्शन ए है वो सही हो जाता है बिकॉज सेक्शन 33 में विटनेस स्टेइंग अब्रॉड वाली चीज को मेंशन नहीं किया गया है. ठीक है. सो when the what is not relevant under section 33, this is option A. Okay. Question number 4. Accused wants to submit a document for consideration under Section 35 of Indian Evidence Act. In which of the following cases will the document become irrelevant? It doesn't deal with the fact and issue. It doesn't deal with the relevant fact. It is not an entry made in public or official book, register or record. It is not an entry made by public servant. So in which of the following cases the document becomes irrelevant? Question number 4. Question number 4. Question number 4 का क्या करेक्ट आंसर होगा बताइए. What is the correct answer of question number 4? Read the question again. Options are: it doesn't deal with fact and issue, it doesn't deal with relevant fact, it is not an entry made in the public or other official book, register or record. So the correct answer of question number 4 is option C. When it is not an entry in the official book or public book, then that document has no relevance as per section 35 of Indian Evidence Act. आपकी जो आंसर राइटिंग की सीरीज़ है वो वाईटी पे यूट्यूब पे हर रोज़ अपलोड होती है आंसर राइटिंग की. सो दैट इज़ अवेलेबल टू यू फ्री ऑफ कॉस्ट एज वेल. Question number 5. A party wants to set aside a judgment under Section 44 of the Indian Evidence Act. In which of the following circumstances can he do so? In case the judgment was passed by a superior court, in case the person challenging is a stranger to the proceedings, in case the judgment was the result of gross negligence, or all of these. Question number 5. बताइए क्वेश्चन नंबर 5 का करेक्ट आंसर. सेक्शन 44 को रिमाइंड कीजिए. In which of the following circumstances can he do so? The correct answer is option A. According to Section 61 of Indian Evidence Act, the contents of documents must be proved by primary evidence. The contents of documents must be proved by the secondary evidence. The contents of documents must be proved by both primary or secondary evidence. The contents of documents must be proved either by primary or secondary evidence. Question number 6. What is Section 61 of the Indian Evidence Act? आंसर बताइए. प्लेन रीडिंग है सेक्शन 61 की. सो द करेक्ट आंसर इज ऑप्शन डी. Definition of the secondary evidence has been given under dash of the Indian Evidence Act, section 61, 62, 63 or 64. Again a section based question, a straight question. What is the correct answer? Question number 7. Definition of secondary evidence has been given under which section of the Indian Evidence Act? So the correct answer is section 63. Now moving ahead to the questions of the Civil Procedure Code. Which of the following deals with the time for inspection when notice given in the CPC? Order 16, Rule 21, Order 4, Rule 13, Order 6, Rule 10, Order 11, Rule 17. Which of the following deals with the time for the inspection? When notice is given in the CPC. So the correct answer to this is which of the following deals with the time for inspection when notice given in the Code of Civil Procedure? Order 16, Rule 12, Order 4, Rule 13, Order 6, Rule 10 or Order 11, Rule 17. The correct answer is Order 11, Rule 17. Which of the following deals with the statement and production of evidence in the CPC? Order 12, Rule 5, Order 14, Rule 20, Order 18, Rule 2 and Order 11, Rule 7. एलिमिनेशन मेथड अपनाएं और बताएं. क्वेश्चन नंबर 2 का करेक्ट आंसर. क्वेश्चन नंबर 2 का करेक्ट आंसर. It is Order 18, Rule 2 that deals with the statement and the production of evidence. Which of the following deals with the right to challenge non-appealable orders in appeal against decrees in the Code of Civil Procedure? Order 43, Order 31, Order 22, Order 9. एलिमिनेट कीजिए. ऑर्डर्स तो सबको पता है कौन सा किससे डील कर रहा है. सो अप्लाई दी एलिमिनेशन मेथड एंड टेल मी द करेक्ट आंसर ऑफ क्वेश्चन नंबर 3. तो ये अपील से डील कर रहा है. तो अपील का कौन सा ऑर्डर है? अपील का कौन सा ऑर्डर है? द करेक्ट आंसर इज ऑप्शन ए. द करेक्ट आंसर इज ऑप्शन ए. In order for that a decision in a former suit may operate as a res judicata, the court which may decide that suit must have been a civil court of competent jurisdiction, a court of exclusive jurisdiction, a court of concurrent jurisdiction competent to try the subsequent suit, a court of limited jurisdiction competent to try the issue raised in the subsequent suit. इसके आपको आगे ऑप्शंस मिलेंगे कि इधर 1 और 2 इज करेक्ट, इधर 2 और 3rd इज करेक्ट, इधर 3rd और 4th इज करेक्ट और ऑल ऑफ दीज. सो दीज आर द स्टेटमेंट्स. रीड अगेन. So all of these statements are correct. All of these statements are correct. Okay. In transaction for transfer or delivery of the property attached where the contract is executed and registered before attachment, the mischief or subsection 1 shall not apply. However, in which of the following situation it applies? Where the property is transferred and registered after attachment, where the property is transferred before attachment but registration takes place after the attachment, both A and B, or none of these. Question number 5. So in both the situations, the mischief of subsection will not apply. The court to amend a decree is the court that passed it. Where an appeal is preferred from a decree of court of first instance, the appellate court may dismiss the appeal under Order 41 Rule 11 Clause 1 without issuing any notice to respondents. The court may confirm, reverse or vary the decree of the court of first instance, either A or B, or none of these. Question number 6. Question number 6. The court may dismiss the appeal or may confirm, reverse it. So it can be either A or B. Which of the following tests are to be applied in cases where the plea of bar of the suit under Order 2 Rule 2 is raised? Whether the cause of action in the previous suit and that in the subsequent suit are identical, whether the relief claimed in the subsequent suit could have been given in the previous suit on the basis of the pleadings filed in that suit, whether the plaintiff omitted to sue for a particular relief on the cause of action which had been disclosed in the previous suit, or all of these. Question number 7. Order 2 Rule 2 बताइए. बताइए, what is the right answer of question number 7? So the correct answer is all of these. So plea of the bar of the suit under Order 2 Rule 2 is raised. Whether the cause of action in the previous suit and subsequent suit are identical, yes. Where the relief claimed in the subsequent suit could have been given in the previous suit, तो वहाँ पर जो है आपके ऊपर बार लग जाता है Order 2 Rule 2 का, that you cannot file a subsequent suit. So this is the correct option, all of these. So आज हमने IPC, CRPC, एविडेंस एक्ट के जो इम्पोर्टेंट कुछ क्वेश्चंस थे, कुछ MCQs थे, वो सॉल्व किए हैं. कल बाकी के एक्ट्स के जो है MCQs देखेंगे. So till then, you all take care and good evening to everyone. Thank you so much.